Okay. So, hi everyone, welcome. Thank you so much for being here this evening, and thank you attendees for being patient to everyone's schedule that we tried to cobble together. We appreciate you all being here this evening. So, I would like you to take a moment to introduce yourself and what you're running for, so our members are aware. And we'll end up rotating the questions, so each candidate will have an opportunity to respond first. There are two races here, and so if you could name specifically which seat you're running for, that would be helpful. So a 1 to 2 minute introduction, and then we'll ask some questions and then open it up to the audience. So, Mr. Bonner, we'd like to start with you, please, and then we will move on. Thank you.
Thank you. Uh, my name is Cabral Bonner. I am running for Alameda County Superior Court Judge Seat 13. I'm a civil rights attorney with extensive courtroom experience as a trial lawyer and as a temporary judge. For the past several years, I presided over small claims matters as a temporary judge in either Oakland or Hayward, work that demands fairness, careful listening, and a genuine commitment to doing justice. From the bench, I see how important it is for judges to be fair and impartial, but only a fraction of a judge's work is actually done on the bench. I'm thankful for my experience as a temporary judge, but of the 60 or so current judicial assignments, around 40 are responsible for criminal or civil trials, long cause trials, jury trials, and therefore litigation experience and jury trial experience will be crucial for this position, which you don't do as a temporary judge. My 20 years of litigation experience have prepared me for the rigors of being a Superior Court judge. I've tried close to 2 dozen trials to juries in California and across the country. I've written and defended all manners of motions during litigation, post-trials motions, appeals. I've briefed and argued before the Ninth Circuit. I'm very familiar with trial practice, including how to make objections, what proper objections. And my practice has been extremely diverse, a wide range of cases, which is what a Superior Court judge has to deal with. They're not going to get the same type of case. They're going to get very different cases, and that's what my practice has been. So based on those things, I will be ready from day one to step into any courtroom and assume uh, that responsibility as a judge. Thank you.
Thank you so much. And Nathan is here for Mr. Johnson, and he was willing to attend our previously scheduled meeting, but again, we had to coordinate schedule, so we appreciate you being here on his behalf. And so I would like you to take a minute or two to discuss his candidacy as well.
Sounds good. And thank you so much for working with us here. We want to make this work for the Berkeley Democratic Club. So we really appreciate the opportunity to discuss Michael's candidacy with the club. I am very happy to be helping Michael's campaign. My name's Nathan. My pronouns are he, him. And really, I could just talk about why I'm supporting Michael. I really like that ever since 2019, he has served as a temporary judge in the Alameda County Superior Court. So he's going in with 7 years of experience, just presiding over hundreds of trials, hearings, arraignments, issues ranging from traffic and small claims. He has training and certification to handle matters of family law and civil harassment. No matter the subject, he's very dedicated to treating litigants, attorneys, and court staff with honesty, patience, and respect. I really appreciate that he works hard to protect everyone's rights under our Constitution. And for that, he has earned a lot of respect and acclaim from presiding judges and court staff. And beyond his work as a temporary judge, he has over 35 years of experience overall inside the courtroom, including in litigation. He has worked on civil rights issues, privacy protection issues, AI issues, corporate accountability, the whole gamut of complex legal areas. And I very much respect that the SF Chronicle has highlighted his breadth of experience with just all these different legal areas is one of their biggest reasons for endorsing in this race. Outside of the courtroom, what really drew me towards this campaign as a nonprofit leader out in Alameda County, I deeply respect his decades of community service. He's mentored at-risk youths at Oakland Tech High School, at De Anza High School. He served on the board of Big Brothers Big Sisters of the East Bay. And we share a strong commitment to expanding legal access for everyone, regardless of background. He was president of the Alameda County Bar Association and helped expand their free and low-cost legal services. And he now is the co-chair of the NAACP Legal Redress Committee, providing legal assistance and guidance and navigation to victims of discrimination and harassment. So I like to have a saying when it comes to just the campaigns I like to help out, big tents and strong tent poles. Michael is the only candidate endorsed by over 35 current and retired judges, by the SF Chronicle, and by dozens of elected and grassroots leaders from every city in Alameda County, from every background, from every political persuasion in our county. It's a strong coalition, and we would love to add the Berkeley Democratic Club to our coalition because we really want to make sure that no point of the county goes unheard with this campaign. So thank you for the time, and I'm excited for your questions.
Thank you so much. And just to be clear, Mr. Bonner and Mr. Johnson are facing each other in this race. And so now we're moving on to the next race. And I would like to invite Ms. Miles to present for 1 to 2 minutes as an opening statement, please.
Good evening, everyone. It's a privilege to be here to speak with you. My name is Patricia Miles. I am a current administrative law judge, already a judge, and have been for 13 years. I handle complex matters pertaining to infrastructure at the California Public Utilities Commission. Important to note that as a judge of 13 years, in addition to my law school and undergraduate education, I regularly participate in mediation training, and I am a mediator at the United States District Court ADR panel and have been doing that for several years. In addition, I've had continuing education on various aspects related to judicial service at the National Judicial College in Reno, Nevada. That's just standard training as an ongoing judge. Before becoming a judge, I was also an attorney of many, about 25 years, represented diverse clients and entities throughout Alameda County. And by the way, I lived in Alameda County for about 26 years. I currently live in another county for no better reason than that I needed to go somewhere where I could afford as a single mom of 2 kids. But I've handled matters for Berkeley Unified School District. I've spent a lot of time in Berkeley and still do. Oakland City Attorney's Office, I represented police and fire cases on behalf of Jane Williams, East Bay Mud, Alameda County Retirement System, and others. Like my colleague, Mr. Johnson and Mr. Bronner, I'm very involved in the community. I have many leadership positions currently. I'm the chair of the California Association of Black Lawyers Judicial Council. I've been the chair of the National Conference of Administrative Law Judiciary at the ABA. I've served on the Commission on Youth at Risk nationally for the American Bar Association. I'm also a member, lifetime member of the NAACP and local bar associations. And I'm very proud of my work in my school district, PTA, site council, et cetera. I'm a parent of 2, so I'm one of those joiners who does all kinds of things in the community. The reason why I'd like your consideration and your endorsement is because I'm making this change because of my desire to work directly with individuals. The work I do is quite complex. I do what judges do every day, listen to witnesses, cross-examine them, make and meet objections, write a decision at the end, and of course, when the decision is on appeal, support my decision. But with the times we live in now, and with the crisis, frankly, that confronts citizens locally, I'd like to be involved on a local level rather than on a statewide level. And with your support, it would be my privilege to serve in the Superior Court.
Thank you so much. And then Ms. Warren, if you could please introduce yourself for 1 to 2 minutes, please. Thank you so much.
Good evening, everyone. My name is Celia Warren, and I'm running for seat 19, Alameda County Superior Court. I've spent more than 20 years as an attorney, primarily in civil litigation. I've studied at the best public universities, UC Berkeley and University of Michigan Law School. I've trained at leading law firms, and since 2015, I have proudly served as a city attorney for Oakland, where I have advised and represented the city in trial and appellate courts, in state and federal court, across a wide range of issues: civil rights, employment, CEQA, public ethics, writs of mandate, restraining orders, and more. The same matter is regularly heard in Superior Court. I'm admitted to practice in all California state courts, every federal trial court in the state, the Ninth Circuit, and the United States Supreme Court, and I've had cases in those courts. In Oakland, we have more work than bodies to do the work, and I'm used to the pace and volume of an under-resourced agency. I'm also active in the Alameda County Bar Association. I've been on various committees, including the Judicial Applicant Evaluation Committee, which is the governor's local committee that helps vet applicants for would-be appointees to the Superior Court. I've seen, and I'm happy to report, that there are many qualified applicants in Alameda County seeking to be judge. But what really stood out for me over my year on that committee was the candidates with the temperament, the humility, and the work ethic. Those are the important qualities, because when you put everyone all together, everyone is qualified. That's the base. But what makes them great are those things. As a judge, I will be fair, impartial, and compassionate. I will follow the law and ensure that every person who enters my courtroom is treated with dignity and respect. I know how intimidating the courtroom can feel, and I will do my part to make sure the courtroom works for everyone, not just those with lawyers. I'm proud to have earned the broad support of leaders and organizations across the country. I would be honored, across the county, I would be honored to earn your support.
Thank you so much. We appreciate those introductions, and now I will ask some of the questions that our board requested that we ask the candidates. So I'm going to ask you to please try to keep, and I know it's challenging, we're going to try to keep answers somewhat concise, because we have multiple candidates here and a few different questions. So the first question, because we're going to allow everybody to have an opportunity to answer the question first, is for, did we lose? Oh, okay, there we go. For Mr. Johnson, Mr. Johnson's representative, how will Mr. Johnson approach decision-making when both sides strongly believe they are right?
Yeah, that's a really great question. Michael's whole campaign is very driven by just a real commitment to impartiality. So I say that because, on the one hand, well, we can break it down into two different questions, right? First is, how do we minimize bias in our legal system? And I deeply respect that Michael has extensive experience in countering bias, both through his work with the Alameda County Bar Association and advocating for professional education and ethical training for local attorneys, to his work as a commissioner at the California State Bar's Judicial Evaluation Committees. Celia did a great reference to just the importance for implicit bias standards when screening judicial applicants and nominees. So Michael has a very strong understanding of just the ethics surrounding enforcing impartiality in verdicts. The second side of it is just in terms of just understanding all the different sides that come in with each case. Michael has an extensive realm of expertise, from civil rights and police accountability, landlord-tenant disputes, tenants' rights, to corporate matters of land use and technology. So I trust that Michael will be able to navigate the importance of just, understanding the cases that come before him, understanding all the different wrinkles and nuances that come with each of these cases, no matter which area of the law comes in. I trust him to do his homework. I trust him to really understand the implicit biases at play in the courtroom and factor figure out how to factor in and factor out both biases. And finally, because of his extensive community experience, I trust him to, and in addition to his endorsements from judicial staff and from judges who have seen his work in action, I trust him to have empathy towards whoever from whoever walks of life come before him in court.
Thank you. Same question. We will go the same order. How do you approach decision making when both sides strongly believe they are right? So, Ms. Miles, yes, thank you.
Oh, okay. I just wanted to make sure I was unmuted. Sorry. I actually find myself in that position daily as a sitting judge. And then I also find myself in that position when I'm serving as an early neutral evaluator for the U.S. District Court or as a mediator for the U.S. District Court. Parties regularly come before judges convinced that they are right. And the key as a judge is to accord each side patience, give them ample opportunity to present their arguments, be aware and schooled on what their various arguments are so that you can ask meaningful questions of them and give each side an opportunity to respond. Bias in my world comes up only with respect to the nature of the discourse in front of me. If someone's less prepared than someone else, it doesn't bode well for them. All judges these days, I believe, take implicit bias training. And we understand, for instance, I'm an African-American woman. We understand that if an African-American woman is in front of me, I don't assume that I know her or her position. I allow her to explain her position to me. And I think that's something that is the hallmark of being a judge. As an attorney, before I became a judge, I was used to arguing one side vigorously. And of course, a good attorney is prepared to poke holes in the other side's argument and heighten his or her own position to the extent they can credibly. But a judge must understand the pluses and minuses, the strengths and weaknesses of each side. You must be very diplomatic with each side and accord them respect and give them ample time to share their positions. And also, you must give the opponent ample time when they make an objection or they lodge a disagreement with the party arguing. It took me a few years as a judge to understand that I was no longer an advocate. I was now the impartial arbiter between two positions. That's something that I think will be a strength should you elect me to Superior Court, because I live in that world daily now. And it's quite a tightrope.
Thank you so much. And next, Ms. Warren, please.
Sure. And the question is, what do you do in the situation where both sides strongly believe they are right?
That is right. How do you approach decision making?
Sure, sure. Well, I've heard a judge say that in their experience, you make a friend for a day and an enemy for life when you're making decisions. And that seems to ring true. I think what matters most from my perspective is what the law says. So, yes, the parties can be very passionate, and we see that every day in Oakland. People that sue us, they are very passionate and confident that they are right in their position. But what matters is what the law says. And I think from a judge's perspective, as long as I ensure that both parties get equal opportunity to present their positions, I hear out their arguments, I read their briefs, then ultimately I still get to make the decision and I will follow what the law says, and that will be my decision. I've said before that I can't promise that people will always be happy with my decisions, but I can promise that I will be transparent and I will be efficient and I will issue them quickly. So for me, the important part is making sure that I've written a strong opinion that lays the groundwork for how I got there, that it has clear citations to case law, and that is well reasoned, so people understand it. They don't have to agree with it. They can appeal my decisions. But that is, in my view, the work of a good judge, and that is when I'm practicing in front of judges. That's what I'm looking for. My favorite judges were not necessarily those that agreed with me every time, but they were the ones that showed up prepared. They'd read the briefs, they were engaged in the case, they were present at the hearing, able to go back and forth and debate a case. And if we asked them to, they were willing to take the matter under submission and ultimately issue a timely opinion. Those are the best judges, and that's what I aspire to be.
Thank you so much. And now we'll go to Mr. Bonner.
Okay. Thank you. It's a very good question, and it was really where I've lived my whole life as a litigator, because in litigation, almost always, both parties believe that they're right, and that's what our process is for. The whole reason we have judges, the whole reason we have courts, is because we want a way for people to resolve conflicts in a way that is civilized and that creates the opportunity for outcomes that both people can live with. Sometimes they hate it, sometimes they don't. I think one of the things I want to emphasize with respect to how I approach decision making is my experience as a mediator. Back in 2014, I started my first mediation training with the Center for Understanding Disputes in Marin County. And then I've had subsequent training in 2019. And then most recently, I've had training for the Northern District Courts Mediation and E&E program. So I'm on their panel. I'm also on the Alameda Superior Court mediation panel. So coming in with a lot of mediation experience trains you in how to ask questions to get to what people's true interests are, not just what they're talking about and complaining about, but what lies beneath that. Depending on the context that I'm working in, there may be opportunities. Lots of judges have to oversee cases where there are not lawyers. For example, there might be something in small claims, there might be something in civil harassment, family law issues. And so part of my training as a mediator, part of my training as a litigator, taking depositions, asking questions, cross-examining, will allow me to really try to ferret out what is really going on with people's approach. Why are they taking the positions that they're taking? Why is it they believe so strongly in their side? What is the evidence that they're looking at? I've also represented a lot of people. I don't represent cities, I don't represent governments, I represent people. So I'm used to talking to people, to helping them understand what their legal issues are. But there are also contexts where, as a judge, my role is really to understand what the law is and then try to fit in the facts that both sides are giving into the law. And regardless of whether both parties believe that they are right, there will be one side that is more right than the other. And a lot of that is going to come from the lens. Everyone wants to be unbiased. Everyone wants to claim those things. But the reality is we all have lived lives. We all are going to see these cases, see the facts before us through the lens of our lived experience. And my lived experience is representing people fighting for justice for individuals. And so, not that I can say how I'm going to decide one case or another, but when I'm looking into how to make a decision when both parties think they're right, I'm going to look for where does justice guide me on this decision? What is the most right decision that I can come up to that is fits with what the law is consistent with the evidence, and is doing justice. And that's one more thing I want to say before I'm done, is that as a litigator, I oftentimes have to wade through massive amounts of evidence. That's what I do as litigator, and those are the skill sets that I'll bring to a judge, as a judge.
Thank you. So for the next series of questions, I will just in the interest of time, because we want to get through, we have a few other questions. I will raise my hand when you're getting about when it's time to close. So I'll make sure that people know, because I was a candidate many times as well, and I would go, well, talk. I would want to talk at length, because you want to make sure to say why you're best for this position. But I will raise my hand, and that means to wrap up the question, just so we can get through and then hopefully get some audience questions as well. Thank you. Thank you so much, everyone. And so the next question, I think it goes to Ms. Miles. Okay, so judges often make decisions with incomplete information and significant consequences. How do you approach those moments? I'm sorry, I can't hear you.
How about now?
Yes, now I can hear you.
Okay.
Thank you. Yeah.
What I said, somewhat in jest, but very seriously, is you approach such situations very carefully, recognizing that the determination you make as a judge can have a significant consequence on someone's life. I was asked hypothetically about something like this just last night in a group situation about parents who might have religious objections to having their child have a transfusion. But if medical opinion is that the child must have the transfusion to live, what would I do? And I think that's typical of the type of situation you're describing. And what is important in a situation like that, first of all, I'll say that I would tend to give a lot of deference to the scientific opinion, but I'd be very compassionate about the parents and their beliefs. And I try to find a way to do what medical science believes is the best outcome for the child without disrespecting the parents' wishes or making them feel diminished because of their religious beliefs. This type of situation of, okay, I think that's enough then.
I'm so sorry, but thank you so much. I do want to hear more. I wish we could talk for hours, but thank you. I really appreciate that. Next up, we will go to Ms. Warren. Let me just reset my timer. 1 second, please. Hang on. Okay, go right ahead.
So I have, in this process of campaigning, also gone out of my way to speak with practitioners in different courts just to get a sense for what the issues are that they see in their courtrooms. And in speaking to family law practitioners, one of the things that they have highlighted for me is actually sort of I think the result of this problem of incomplete info with significant consequences. And from their perspective, too often judges are kicking the can down the road because they're afraid to make a decision. They're sort of taking it under submission and then making the parties come back at a later time, when in reality, at least the practitioners that I'm talking to who have been doing this for a really long time feel that it would be better to make a decision and then check in with the parties to see how it's going after that. So it's almost the opposite of this problem. And I think judges can be fearful of making the wrong decision to a point where they are almost paralyzed from making a decision. And I think that is also a problem. And so from my perspective, and especially it helps getting that feedback, I would be more willing to make a decision and revisit it as needed if that is available to me. And to make a decision, ultimately, we're always making decisions without complete info. So you have to be comfortable making decisions, and I am.
Thank you. Okay, next up, Mr. Bonner.
Okay, so the idea of making a decision with incomplete information but serious consequences, I think I would start from a place of just understanding that, probably stating that to whomever I was making the decision, being open and transparent and being humble with the fact that this is the decision I'm making with the information I have. I would be open in those type of situations to revisiting it, and I would let the litigants or the people involved know that if more information comes to light. But I would try to make sure that they understood the process, that they understood that while this decision was being made, I was letting them understand the context I was making it in. I have oftentimes in litigation, judges will ask you, hey, I need more information, I need more briefing. I can't make the decision with the information I have. And we respond with more briefing. So I wouldn't be afraid to putting some of that, if there's attorneys involved, putting that on the attorneys to provide more information, more briefing. But I think I would start with being from a place of understanding that I'm not infallible. I'm going to make the best decision I can make right now with the information I have, understanding that is my decision. I'm going to own it, but I'm going to be humble about it and make sure that people understand that if more information comes around, that I'd be interested in revisiting it, open to revisiting it. Yeah.
Thank you so much. And I appreciate all of you for, I know these are rapid fire questions, so I appreciate that. So next up, we will go to Mr. Johnson's representative.
I would summarize at least my understanding of how Michael goes about incomplete information and significant consequences. I summarize it as empathy and expertise. At least that's how I view his career. Let's look at empathy as a temporary judge whenever he has non-native English speakers coming before him in court. Takes a minute to check in, make sure they understand the legal process they're going through and refer them to an interpreter as they need. Then he takes the extra step outside of that courtroom to advocate for even more of those interpreters, making sure that we're properly staffed, resourced, that our case management system understands this crucial need for language access, giving a traffic attendant a moment to breathe, and then making sure that she understands the process that she's going through. Because let's be real, if you're going for someone like Michael for a traffic violation, it's probably not one of your best days in your life. But on the flip side of empathy is his expertise. We talked a lot, he and I have spoken a lot about how he's been at the cutting edge of the California Consumer Privacy Act and the cutting edge of HIPAA back when he was working for a major data company. He was faced with tough questions about how do you protect digital privacy when state and federal laws either didn't exist to protect those rights, or they had just been passed and we don't really have many precedents to follow. Being faced with tough questions that no other attorney has faced before and setting a precedent that other consumer protection attorneys would follow, that's very much his expertise. And taking in cases of harassment and discrimination within WCP and directing those victims towards the best possible path to justice, very up his wheelhouse. So I very much trust him to handle those sorts of dilemmas.
Great, thank you. Okay, our next question is for Ms. Warren, and this is sort of related in a way, and that's that courts face pressure to move cases quickly. So how do you balance efficiency with careful consideration?
Yeah, I think that's a great question, and I think that's the constant pressure to do that, to move efficiently and to give cases the proper due. And I think that even comes down to on a individual cases, on an interpersonal basis, when you have, for example, a non-native speaker or somebody who is differently abled in terms of their verbal abilities, you do need to slow it down to make sure that they understand the proceedings, to make sure that the proceedings are fair to them. And in my mind, giving different amounts of time to different cases is fair, is equality, is equity, because not everybody needs that extra time. And so that's one part. There's also just this sort of more practical part of administering cases. And like I said earlier, the best judges to me were the ones that were prepared at the hearing and issued their opinions quickly after the hearing. Nothing is worse than having a huge motion that then sits under submission for months, because the parties are trying to plan for trial and they're trying to decide, is this case, amenable to settlement? But without the pressure of that opinion, sometimes the parties are not inclined to make those kinds of big decisions. And so I think, it's a case by case basis, but if you have the general mentality that we need to keep this moving, then I think you'll be okay in addressing the individual cases that way. And in Oakland, I'm used to the more work than bodies to do the work. So yeah, I'm good with the pace.
Thank you. Okay, and Mr. Bonner. So the question once again is, courts face pressure to move cases quickly. How do you balance efficiency with careful consideration?
Okay. So I currently run my own practice, and efficiency with careful consideration is what I have to do in order to stay in business. I have to look not only at how to do things right, but how to do them efficiently and do them smart in a smart way. One thing as a with respect to being an Alameda County Superior Court judge, I would try to utilize some of the tools that they have in order to route cases to the hopefully the most efficient exit, because not all cases are going to end up in jury trials. I mean, this is for the civil context. So there's a couple things that you can do in Alameda County. I know because as from practicing there, they try to send cases early to some type of alternative dispute resolution. If you can get a case before a good mediator and get it resolved, that's going to reduce a lot of the burden on the courts. Courts are also using something called an informal discovery conference, an IDC. That's where instead of filing a motion because they're not giving you the documents that you think they should give you, instead of filing a motion, which are very voluminous motions, take a lot of court time, the courts and the judges are meeting with the litigants to work out what are the problems going on with the discovery and how can the judge issue an interim order to move the parties along towards finalizing that. So I'd utilize those type of tools to reduce the burden in order to give the right amount of time and work smarter, not harder.
Thank you. And next up, we'll go to Mr. Johnson's rep.
I would say that Michael really champions an understanding of not just every walk of life, like I've been referring to, but also every possible resource the court system can offer. So that means understanding, of course, the fundamentals of case management and ensuring that there's no backlog of cases just jamming up the wheels here, because nothing really undermines public confidence, public trust in our legal system than, well, either bias or inefficiency. And I am very glad that over 35 current and former judges, as well as many court staffers and many attorneys who have gone before him, are vouching actively for Michael's expertise with clearing backlogs, with moving processes along. At the same time, we shouldn't be risking pushing along processes and not accounting for folks' difficulties with those processes. So really being understanding of any issues of language access or even legal access. How can we make sure that self-represented litigants are having a fair day in court? How can we make sure that folks with issues with linguistic abilities are not blocked from a fair day in court? So really, to wrap it up, I very much trust Michael to stay on top of every motion, to stay decisive and transparent, but also he has this wealth of administrative and legal experience where we can trust him to be efficient and very careful in how he handles every case that comes before him.
Thank you. And Ms. Miles. Again, the question is, courts face pressures to move cases quickly. How do you balance efficiency with careful consideration?
I think my colleagues have all hit on very important points, and I agree with much of what I've heard up to this point. The only thing I'll add is that someone said that it's important that to keep respect for the judicial system, we are seen as not biased and also as fairly efficient. And it's my concern for the legal system that leads me to make sure that parties appearing before me have done reasonable efforts between themselves before they come before me. Now, admittedly, I feel that way because I spend a lot of time mediating matters and often gets things off of the litigation docket, because we often find that people literally haven't taken the time to make a phone call to one another and see if there are areas that they can agree on. But in Superior Court, more often than in my current situation, there are often people who are not represented. When I was an attorney handling workplace injury cases, discrimination cases, often those types of cases were brought by someone on their own behalf, looking for justice in the courts and having an expectation based on what they see on television or something like that. So I think it's important to make sure parties understand the process, make sure that they've taken steps to try to address what they can before they come before me. And then, of course, I'd be very careful and patient in trying to help them find their way to a resolution. I want to say, half jokingly, because I'm a judge, when you put your hand up, I take it seriously because I'm a judge. And when I put my hand up, I expect people to stop. But I don't think
Oh, I didn't know that.
everybody sees it the same way. So,
Okay,
I
thank
feel
you.
like I cheat myself a little. When I see your hand go up, it means something to me.
Okay,
But
great. Thank you so much. All right. And so the next, so I want to be mindful of your time, but we have one other board question. And so we will ask Mr. Bonner first, and I will, I'm going to try to really limit it this time. So I'll make sure my hand's very visible. And that is, and many of you have touched on this issue before, before asking this question, and that is public trust in the judiciary is critical. So what builds trust in a judge, and how would you maintain it? Just a small question that you'll have a very small amount of time to answer. And so, so once again, what builds trust in a judge, and how would you maintain it? So I will start with you, Mr. Bonner.
You build trust as a judge by being fair and allowing the litigants or the attorneys that are appearing in your court to have their day in court. I've been before judges where I knew for a fact that their thumb was on the scale of justice and the other side was being treated preferentially. That does not build trust. When I go to trial, I want to not know what the judge thinks about the case. You shouldn't know. The judge should be, a blank slate as far as their subjective opinion about it, because really the jury is the one who should be making those type of decisions. So the things that judges do, and it may be simple things like body language, like shifting, like looking at the defense table when they think they should be objecting. There are little things that judges do that make a big difference in terms of making the attorneys feel like they are trusting that judge. And the broader community will only interact with judges infrequently, but it starts with how the attorneys and the people who are in the court see them. And if I can I just make one closing remark? I didn't know if that's
10 seconds. Go for
10
it.
seconds. Okay. And one thing that I would like to say about that is Judge James Riley, who is the seat 13 judge right now, he is supporting my efforts. He believes that I am the best candidate to replace him on that judge and follow in his footsteps in the career he's had as the Alameda County seat 13 Superior Court judge.
Thank you. Okay, and next up we have Mr. Johnson. Nathan, how would Mr. Johnson build trust in a judge, and how would he maintain it?
I would say that process is happening right now. It's something that I've spoken with all the other candidates here, and I have a lot of respect for all of you, and we've all have wondered, why do we have judges even run for office? Why is this a campaigning role? Well, campaigning means going out there. Campaigning means working hard. It means building bridges. And even before he set his sights on running for judge, Michael's been out there. He's been out there with NWCP. He's been out there with the 100 Black Men of the Bay Area. He's been out there with APAPA. He's been out there engaging with Black, Brown, Asian, immigrant communities, longtime residents, transplants, young professionals like myself. He's out there learning as much as he can, showing up, letting people know that judges are also supposed to be community leaders. Judges are supposed to be democratically accountable. Judges, it's great for judges to endorse each other. It's great for attorneys to endorse each other. And it's great that we have folks ranging from one of our former presiding judges, Charles Smiley, who's now serving us at a higher level at the state, to his own mentor in the world of civil rights, John Burris, endorsing him. But we also have so many other community leaders backing him up too.
Thank you. Okay, and next up, Ms. Miles.
This is a very important question and timely because we're in a time now where judges are routinely derided from the highest levels of government and threatened and spoken about with complete disrespect. And so as a result, I feel particularly committed to making sure that when I'm in my robe and in my role as a judge and people are in front of me, that they understand how seriously I regard them, how seriously I regard their right to due process, how seriously I regard the Constitution and the judicial process. I think it is very important that, and again, what everyone has said, but it's important for judges to convey to people in front of them that we have lived a life that gives us understanding of the person in front of us, and that we respect the fact that they've come in front of us, and that we're going to, as my colleague said, give them their day in court and accord them empathy and respect.
Thank you so much. And next up, Ms. Lehman.
Yes, that's a fantastic question. And like Cabral, I've had the experience of a judge very much, probably unintentionally, but showing preference against my client. And I can tell you that is painful in front of a jury. It's very important that the perception and the experience for parties in court is that they are being treated fairly, because then you start to lose trust if that's not your experience. You certainly judge the particular judges, but it also impacts your experience of and perception of the system in general. It is fundamental to the system that people perceive and are treated fairly, full stop. There's also the written opinions, giving clear, transparent opinions that make the basis of your opinions clear to everybody is also fundamental to building trust from the public and with the parties. There are no because I said so's, there are no because I told you so's in court. There are only well-reasoned, thoughtful opinions, and that should hold true also in your verbal rulings. I come from a multi-ethnic family. I was raised in a diverse county, and I'm working in the most diverse city in our county. Working well with everybody and seeing everybody of diverse backgrounds is also fundamental to our system, and I do that well.
Thank you. All right. Well, thank you all. I really love having these in-depth conversations, even though we can't chat for as long as I'd like to. And you know, I find judicial races to be among the most challenging to try to figure out how to vote. So it's really nice to hear from you all. I have one written question, and unless I have an additional, I received more emailed questions or that some are in the chat. After this question, I will ask you all to have a minute closing. The question that we received is for Mr. Bonner. In the Hunters Point shipyard case, a federal judge raised concerns about the fairness in the proposed settlements. As a judicial candidate, how do you reflect on that experience, and what did it teach you about ensuring fairness from the bench?
I appreciated the judge's position, and I understood why the judge made the decision that the judge decided. What I think it taught me is, first of all, as a litigator, it's important to make sure everybody understands the complexities of things that go on. You read about what happened and what the judge said. The judge read about what we put in the papers, but there were some fundamental things that the judge, I don't think, understood in this particular case. And it taught me that it's very important to make sure there are very clear that you're being very clear in where your position is. And I don't know how much time I have. It's wildly complicated, but this particular case in Hunters Point, I represent 6,500 individual community members of the Hunters Point community in a case against two main defendants. One is called Tetra Tech, the other is called Lennar. Tetra Tech had a contract from the Navy to clean up the Hunters Point Naval Shipyard. Lennar is a developer. In this particular case, Lennar was also suing Tetra Tech. So the way the litigation worked out, Lennar and our firm, Lennar's attorneys and our firm, and several other firms who were all suing Tetra Tech, had to coordinate our efforts. And the judge saw that as being as part of the basis for his determination. As it turns out, we were able to get much more money for our clients through further negotiations. We have settled with both Lennar and Tetra Tech. The settlement was approved by the judge. The minors' compromises were approved by the judge. And so, and I think part of that was my learning from that first incident and being a little bit more clear in how we communicated what was going on the next time. Thank you for that question.
Thank you. And thank you, other candidates, for, I figured I would give you more time to talk since it was a question just to you. I don't see any other questions here. So I'd like to have each of you wrap up for 1 minute each, and I'd like to, going in the same order, I'd like to have then Nathan, and then we'll go in the same order again. And just 1 minute, please, because we're so curious to hear from you all, we're running a little bit behind time. So 1 minute to wrap up, please. Thank you so much. Go right
Thank
ahead.
you. So I have said plenty from my point of view as to why I'm supporting Michael. I'll let Michael finish this off in his own words. And what he had drafted to pass along is really a thank you. Thank you again for your time and consideration tonight. Thank you again for just granting so many members of our community the opportunity to learn about a race that, we're dealing with very qualified candidates. It's important that we hear all the different perspectives and all the professional backgrounds and all the qualifications. At the end of the day, this election is about ensuring that our courts remain grounded in fairness, integrity, and equal access to justice. With more than 35 years of legal experience, deep roots in Alameda County, and service as a temporary judge since 2019, presiding over hundreds of matters, I, Michael Johnson, am prepared to serve with the judgment and impartiality this role demands. I am proud of the broad support that this campaign has earned from community members, including leaders from the Asian Pacific American Democratic Caucus, and from our various unions, to elected leaders like Senator Jesse Aragon, and I remain committed to a simple principle that everyone who enters the courtroom is treated with dignity, heard fully, and judged fairly under the law. Thank you.
Thank you. And next up, we will go to Ms. Miles.
Thank you. It certainly is a privilege to have the opportunity to introduce myself to you tonight. And I want to say that what I enjoy the most about an otherwise arduous effort as a candidate is the opportunity to speak to members of the public and hear what people expect of me as a judge, hear what they don't understand about our judicial system, and most importantly, to have them walk away with the understanding that I'm very much like them, a person who cares about what I see going on around us in our community, cares about our democracy, cares about the erosion, it appears at the moment, of our democracy and of the rule of law. And, we're all standing in the same point in time in history. And it's been very rewarding to see that fellow citizens here in Alameda County care as much as I do about my role as a judge. It would be my privilege to serve in Alameda County Superior Court. I am a judge seeking a different type of judge role, primarily because I want to be closer to individuals day to day. But it certainly doesn't in any way diminish my belief that what I'm doing now in serving you from the state bench is equally important. So I thank you for giving me your consideration.
Thank you so much. Okay, and Ms. Warren.
Thank you for the opportunity to speak to you tonight. Too many people are trying to navigate our courts without attorneys. As a judge, I will make sure people feel seen and heard and that the proceedings are clear and understandable. I will apply the law faithfully, protecting consumers and voters, safeguarding workers' rights, and upholding our constitutional rights, including the right to choose to have an abortion. I understand the importance of judicial independence. I have stood up to federal overreach, and if called upon from the bench, I will remain steady under pressure, guided by the rule of law and not intimidation. A retired justice of the Court of Appeal once said that to be a good judge, you need the soul of a poet and the hide of a rhino. I lead with compassion and humility, and I bring the toughness this job requires, raised in Vallejo, sharpened by Berkeley, and fortified by a decade serving Oakland. Leaders and organizations across our county stand with me because they trust my experience, values, work ethic, and temperament. I would be honored if you stood with me as well.
Thank you so much. Okay, and Mr. Bonner.
All right. Thank you all for your time. The good news is you don't have any bad options. There's no wrong decisions here. So I think you should feel good about that. I'm a civil rights attorney because my father, who was born in Selma, Alabama, at the age of 16, joined his fellow high school students in a protest across the Edmund Pettus Bridge on Bloody Sunday. And his experience in the civil rights movement formed the foundation for the legal practice he started in Oakland in 1979, which I joined in 2006 after I graduated from Stanford Law School. Compassion, equity, and empathy have been my guiding principles throughout my career. In addition to, I want to talk a little bit about my endorsements. I've been endorsed by Latifah Simon, the SEIU, the Alameda Labor Council, the Longshoremen. As I mentioned before, the current sitting Alameda County Seat 13 Judge, James Riley. And I think that's important. James Riley had the opportunity to vet me. He spoke with me, he understood my background, he understood my experience. He also had an opportunity to vet my opponent, understood his background, understood his experience. And the person who's leaving the seat thought the best person to replace him was me, based on our experiences. I think that speaks volumes. And the reason that is because I've spent my life and my career in the courtroom doing justice. Thank you.
Thank you all so much for taking this time. We really appreciate you being here. As a reminder, our membership will get an electronic ballot over the course of the next few days, and they will vote, and we'll let you know as soon as we receive the membership votes. So thank you again, and we're going to move on to the district attorney race. I want to thank the candidates. Thank you all for being here, and then also for waiting because we're running a little bit behind. So let's see. Am I okay? Good. I think everybody's been. And now I'm going to promote the candidates for district attorney. So here we go. And here we go. And here we are. Okay. All right. Well, we are concluding our evening with you all, and we appreciate you being here this evening.
Cool.
Thank you for taking the time, and I apologize, we're running a little bit behind. I'll try to abbreviate some of the questions, but we thank you for being here. So let's just jump right into it, and I'll try to be a little bit firmer with my time limits. So I apologize in advance if I have to interrupt. But first, I'd like to go and ask everyone for a 1 minute, max 1.5 minutes opening statement on why you believe you should be supported as district attorney of Alameda County. So we will go first with Ms. Jones-Dixon and ask you to have your opening statement for a minute to a minute and a half, and then we'll move on alphabetically by last name. So,
Okay, can you guys hear me?
yes, welcome.
Perfect. Sorry, I'm at an event, so I apologize for the noise. I'm Ursula Jones-Dixon, Alameda County District Attorney. The reason I think it's important to do this job is because I think at the center of everything a district attorney should do, things should be fair and impartial, and we should be looking at victims' rights. And I think that the focus on victims' rights is something that is necessary, that's required and has been desired by our community. My background as a deputy DA and then as a judge in Alameda County helped me to be uniquely qualified for this position, having spent my entire legal career in the courts in Alameda County. And in addition to that, my ability to do the work in a fair and impartial way. I am looking to serve again as a public servant, Alameda County as the DA, as long as you will have me. And the ultimate, I think, concern for me is how we get the district attorney's office back to where it should be so that we are serving the interest of victims, as well as making sure that defendants in this process have a fair and impartial walk and journey as well. Thank you.
Thank you so much. And next we will go to Mr. Krishan. Welcome. One max 1.5 minutes opening statement.
Thank you, everybody, and have a great good evening. Yes, it was a little late. I logged in around at 6. That was the time I got in the email, but that's okay. My name is Gopal, and I came from India. I came here, didn't have the law degree here, the credentials. So I studied here, passed the bar exam as a foreign lawyer. It was very, very hard for me. My wife helped me. We lived in Nebraska at that time. Moved to California after passing the bar exam. Alameda County is my home. I made this county as my home. Since then, I have started my practice. I have talked to many clients. And in those more than 15 years, I have helped people. I haven't worked for the government. I haven't worked for the cities. I have worked for the real people. And I'm still working with those real people. So when it comes to that, why it is important, it is important for me because I have talked to many people. I do immigration practice, and I have seen many of my clients, they are still scared of ICE even after they have the green card and they have the citizenship. And I have talked to many victims of the hate crimes. And in fact, I had a meet and greet yesterday and day before yesterday. I did talk to many victims of those. Sometimes they don't even know that they are the victim of that. I have seen and I have walked with the families and the business owners. They started their business, but they have to close it down within very few years because of the organized crime. And I think nobody's doing anything about that. And that's the reason I think I should be running for the district attorney. And these are my priorities. No ICE in Alameda County, no hate crime, and I will be tough on the organized crime.
Thank you so much. Next, we will go to Ms. Price. Welcome.
Yes, thank you. Move this thing out of the way. All right. Good evening, Berkeley Democrats. Thank you for having me. I'm running for re-election because I'm one to stand up against Donald Trump for the people of our county. I'm running because I firmly believe that justice should be served without hesitation, without favoritism, or fear. You know, my top priority is has been and will continue to be keeping the people of Alameda County safe and ensuring that justice is fair. The news of the day affirms my commitment to run. The surge of immigrant arrests in Northern California is very troubling. The surge in gun violence in particular places, my community, Oakland. Police misconduct is on the rise again, and prosecutorial negligence is being displayed with no investigations of the public officials. So in my first term, We tackled gun violence, organized retail theft, and crimes against women and children. We processed cases at a higher rate than my predecessor. We expanded services and improved services dramatically for victims. We increased the number and diversity of the entire workforce by hiring 200 professionals. We reduced historic backlogs and created a public dashboard so that the public would be able to see what was happening with the cases, how long they were pending, and where the backlogs were. We received millions of dollars in judgments and settlements to support our work, and we advanced the use of technology, bringing the office forward from the Stone Ages. So those are just a few of our accomplishments, and the work is not finished. Thank you.
So much. Okay, and so the next question that we have for you all and we're going to start with the general question and then move on to individuals. So we're going to start with now Mr. Krishan. What specific policies would you prioritize to reduce violent crime, and how will you measure success?
So violent crime, they are the root cause of having no public safety. And I have seen it, they are ghost guns. Then above all, they're organized groups. They train people, they provide resources, they provide fences, and they promote them to carry the guns. These are the violent crimes. So if we have to prioritize one violent crime at a time, it will be extremely hard to make the Alameda County safer. So my aim is to work with the organized crime, to curb the organized crime in Alameda County, including the violent crime. That's one approach. Second is I'm going to have very clear policy. If somebody is doing a violent crime, somebody is involved in a violent crime, that person will go to the jail. We're going to ask for the punishment. There is no diversion for that. There is no other relief for that. There is no reform process for that. Violent crime has to go to the jail. We have to be smart on crime. That doesn't mean we can actually let the violent criminals go. They affect our society first-handed. They break the system, they break the confidence, and they have the long-term ongoing consequences to damage the public safety in the county, not in the county, in any society. So we have to set an example that if somebody is doing a violent crime, that person has to be punished.
Thank you. Next, we will go to Ms. Price. The question is, what specific policies would you prioritize to reduce violent crime, and how will you measure success?
Sure. There were a couple of things we were doing and we would continue to do. Number one is addressing gun violence. We published a report on gun violence and convened a series of roundtables. So we need a regional strategy for gun violence. We got a $5.5 million grant to work with the courts on gun violence restraining orders, which I think are a critical tool in reducing access to firearms as well as the use of firearms by people who shouldn't have them. Domestic violence. We're working on a unified court, and Alameda County needs to have a unified court to deal with domestic violence cases. Too often when we see violent crime, we see that it started with incidents of domestic violence that were not properly addressed in our court system and through our own system. So also child abuse, tracking child abuse cases was a priority for our administration, and getting the electronic suspected child abuse technology in place and being able to use that technology, making sure that my deputies are aware of it, as well as being aware of the gun violence restraining orders, which we need more. We would do training on that as well. Last but not least, working with young people, making sure that we are engaging with community organizations, community-based organizations that are about helping young people understand why violence is bad, why it doesn't work. When there are incidents of violence, making sure that there's no retaliation. We fully supported the ceasefire strategy in Oakland, and we worked with other intervention organizations like Youth Alive. Thank you.
Thank you.
Ready, Lauren?
Yes.
So as it relates to priorities, of course, for us, it's violent crime and making sure that victims are seeing their days in court and being supported. I'm interested in the other answers because specifically as it relates to violent crimes right now, the law is such that if there is a diversionary process by way of mental health diversion, the DA cannot stop someone from going into mental health diversion up to an attempt murder. So that is not something the DA can actually stop. We can make an argument, bring an expert witness in to say, no, we don't want that to be the case, but the DA does not have the call to make there. And as it relates to gun violence, I mean, it's a big piece of why we are doing what we're doing, specifically for victims. I think that there's so many victims of gun violence who have spoken to us about their concerns about not having cases charged with the appropriate enhancements before we got there, and feeling like when there is a crime with a gun, people are in jail and out of jail so quickly that we've turned that around and allowed the opportunity for our DAs to actually charge cases with those enhancements so that people who are using guns in the commission of a crime are actually punished appropriately for doing so. So our priorities are violence as well as victims' rights.
Thank you.
Do we have a rebuttal time at all? I don't know.
At the closing statement, you can. Yeah.
Oh, okay. All right. Thank you. I'll
Thank
make
you.
my notes. Thank you.
And then the next question that we'll direct to you, Ms. Price, is prosecutors have enormous discretion that can shape outcomes at every stage, from charging to plea deals to sentencing. How would you ensure that discretion is exercised consistently, fairly, and in a way that the public can trust?
Sure. First of all, most importantly, you need to have a policy by which all charging deputies, and there are approximately 37, under my administration, there were 36 charging deputies charging in 7 different locations around the county. So there's no way to know what each deputy is doing or how they're charging in each location unless you have a policy and you have some supervisory, communication between the supervisors about what cases, how they're charging them, and what standards they're using. There's a basic standard of what can you prove it beyond a reasonable doubt. But beyond that, the discretion, one prosecutor could charge, 5 enhancements, another one could charge no enhancements. So you really have to have a policy whereby you standardize the use of their discretion and you have some oversight and you begin to have some education about what the law actually requires and what the expectation is. So that's first and foremost. Then you need transparency. Again, we had a public dashboard so that the public, we created that. It took us a year so that the public could see what cases we had, what we were getting, and how they were being charged. Also, you want to look at prosecutors have to rely upon police reports. So if Berkeley PD has one standard for how they present the cases and Fremont has another standard, that makes it difficult for our deputies to determine, okay, what are we doing here? So again, you have to have coordination and communication within the office and clear strategies for how you're going to move forward with charging cases. That's my answer.
Thank you. And next we will go to Ms. Jones-Dickson.
Same question.
Yes, please. Thank you. So I'll repeat it. Prosecutors have enormous discretion that can shape outcomes at every stage, from charging to plea deals to sentencing. How will you ensure that discretion is exercised consistently, fairly, and in a way that the public can trust?
So I think it's really important to remember that we put people in positions to charge who have the experience to do so. When people know what they're doing, they should have the ability to use, for example, enhancements as they see fit, because no case is the same. It's fact specific. And, I think the concerning piece is that under the last administration, there were these directives in place that allow for the backlog that created thousands and thousands of cases that did not get charged. And that for me it means that victims are not seeing their day in court. They are not having their cases reviewed, et cetera. So the goal is to put the right people in place, have meetings with them as we do every month about charging issues that come up with charging as well. As it relates to the data dashboard that
we lost
was in place, it was taken down because we realized that the data in it was inaccurate. In addition to that, counties across the state are removing dashboard because there are concerns about that information, providing detailed information about immigrants in our community as well. So that dashboard will be up, making sure that it has no identifiable information within the next quarter.
So I just want to say that we have a little bit of a challenging time hearing you. I heard it. It was a little bit hard to hear, but just for the future questions, I just wanted to make sure. I know you might be holding the laptop. We appreciate you taking the time. Okay, and then Mr. Krishan, same question.
Thank you. So we have to have a measurable system so that we can measure that this is what we are doing and we are doing in a consistent way and we are going in the right direction. So and to do that, the system we have to develop, it has to be impartial, it has to be available for everybody. That comes to the transparency. I did talk about many times about the data point, data sheets, and to use the newer technology for the processing. So the very first thing, and that's my plan to implement within 90 days, I can work with the IT department of the Alameda County. We can use the current system and we can make it add some more data sheets which are available, which will have that what are the charging policies, how we are charging, how we are implementing. And once we have collected that data, within a week or say within 10 to 15 days, we will have enough data to make sure that will reflect that are we charging a specific group more than others? Are we giving the diversion program to a specific group more than others? And if we are doing that, it means, yes, we have found a problem and we can fix that. So that's the reason we have to have a measurable system. That's the one. The same thing goes for the transparency as well. We have to have the accountability. Without the transparency, there is no accountability. We have to have everything open in the public. We have to make sure as a district attorney that these are the policies, and with these policies, if you're doing something wrong, it will be charged. So once we have those charging policies, sentencing policy, diversion policy clear to the public and to the other ADAs, they will have the autonomy to make those decisions and the public have the visibility on it.
Thank you. Okay, and now we will move to, who am I starting with now? Now I forget. Who went, who went first last time? Oh, I'm starting with, okay, thank you. Thank you so much. Okay, so now we're going to ask specific questions to the specific candidates, and then we'll open it up to questions from the audience. You can email, if you look in the chat, the questions, you can put it in the Q&A, or you can raise your hand. So for Ms. Jones-Dickson, one question specifically for you is, you reversed several policies from the previous administration. What guided those decisions, and how will you evaluate their effectiveness?
So what guided that decision was how effective the policies were. To start with, the issues around, sorry, you guys okay on the audio? Yes?
Better now with this, however you just adjusted it. Yeah.
Okay. So what caused me to make that decision is how ineffective the policies were. I'll start with the charging directives. That is how we got into a situation where we had thousands of cases that had not been charged. That was the first thing that I did when I walked in the door, was to reverse those directives, because it required that individuals go up multiple layers of supervisors to make a determination on whether or not they could charge an enhancement in a case that, for example, was a murder case. In a case that, for example, was a shooting case where there's a victim of a shooting. That doesn't make sense. It never made sense, and it's not going to make sense. So that was one of the reasons. And the way that I see that is effective is that we are working through that backlog of cases quite a bit. And in fact, more cases are coming to us for review from police agencies because they had stopped bringing the cases and victims had stopped making calls to the police to do so because nobody knew what happened to the cases that they were reporting. So it's really important to make sure that we are efficient and effective in doing the work on behalf of the victims in the community. That is one of the things that I felt was important to make sure that we did. And then secondarily, we made sure that we went back to the basics to make conversations and communications between the victim and the DA's office a priority. because what we found were that there were many victims who had not been spoken to about what was happening with their cases, how it was going to be resolved, and had not been, their Marcy's rights had not been adhered to, none of the 17 enumerated rights. And so we went back to the basics to make sure that we're creating that line of communication between the DA's office and victims as required by law.
Thank you. And next we'll go to Mr. Krishan. Coming from a family law background, how will you build the prosecutorial expertise and management structure needed to lead a large DA's office?
I have been asked this question a few times. So if you see my practice, it is not just the family laws. I started with the immigration, got into the family laws. Then my client, they started their businesses, and I grew with my clients. I told you when I came to United States, I didn't have any family. I had clients. The clients they turned into friends, and those friends they turned into my family. So I have practice for almost every type of cases. Yes, the majority of the revenue comes from the few family laws and the business laws and the civil cases, I would say that. But it is not that important. The important part is, can I run a big practice which has the prosecutor? So it breaks down into two parts. Do I have the experience to run the criminal case? The answer is yes. I have the experience about the criminal cases. The second part is, do I have the experience to run a large office? The answer is yes. I have the experience of the large office practice, and above all, you need to see the current district attorney and the district attorney before that. We had many debates. The district attorney office has about $110 million budget, and I don't see efficiency in it. As a successful businessman, I know the value of the efficiency. I can use the higher tax, which can increase the current district attorney office at least by 200%. Without firing anybody, we can increase the budget, we can increase the funding, and we can increase the resources, because we have to optimize those resources. It is the lack of the leadership which is creating the backlogs. It is the lack of the willingness to adopt new technology. I have the processing technology. I'm not transferring the decision-making power. But when you have the right information, think like that. You have a paralegal will give you the brief. By the end of the day, you will make a decision. That's how I'm going to run the district attorney office. Thank you.
Thank you. And Ms. Price, reflecting on your time in office, what is one decision you would handle differently, and what did you learn from it?
Sure. The one glaring thing that we learned was around communicating with the media. We maintained the original staff that Ms. O'Malley had when we got there, and that clearly was a mistake because they were not ready for the onslaught of media attention that we received in the first 90 days. And so people outside the office were able to create a false narrative about what was happening in the office. One of the things that I learned is that culture, I knew going in, because I have management experience over 30 years, is that culture eats policy for lunch. And so the culture in the office, which I misjudged, I will say, the level of sort of resistance to change, that people were not willing to accept someone from outside the office over time. And we thought that we would make headway, and we were making headway. We hired 200 people. And so I really thought we turned the corner by the end of 2023 in terms of bringing the office back to being able to move forward and having them accept the people who had been there for years. It's Alameda County is a very insular office. And so it was very challenging to get them to accept new people coming into the office. We brought folks that had been prosecutors in Marin and San Francisco and Santa Clara from around the state. And we told them, if you're from Alameda County, but you practice law, you work in a DA's office somewhere else, we want you to come home. And that was very challenging for them because the people who had been raised in the office, like Ms. Jones-Dixon, they didn't want new people coming into the office. And so there was a lot of resistance, not only to myself as a person coming in from the outside with a mandate to reform the office. There was resistance to my team. There was resistance to the people that we hired. And yeah, so.
Okay, thank you so much. So, of course, I have many other questions, but I want to be mindful of time. And I've only received one emailed question. If anyone has questions in the audience, please raise your virtual hand, put it in the Q&A, or email it to info@berkeleydemocraticclub.com. So I'll read I'll read the question I have now, and if we don't have any other questions, I will ask you to close with your statement. During your closing statement, if you want to talk about anything else that was mentioned, feel free to, but you'll still have the same allotted amount of time.
Yeah.
Okay.
Lori, can I question? I would like to have more time to rebut some of the misinformation that was made about my administration and our policies.
I'll give everybody equal time just so it's fair.
Okay.
So that way everybody will have equal time. And if people are willing to hang out, that's great. We would love to hear from you all equally. Okay, so the question that we've received is for Ms. Price. Can you give an example of when, what is it, of when you would take, a more traditional prosecutorial approach, even if it conflicts with your broader reform philosophy?
Sure. The effort that we made to reform the domestic violence court was very important to us. And even though it wasn't, there's always going to be a tension when you're talking about gender justice between the traditional approach to just incarcerating people, or also the traditional approach, quite frankly, of not respecting women who are in abusive situations, which I have personal knowledge of and spent years. I'm the founder of the Bay Area Defense Committee for Battered Women out of Berkeley, while I was in law school, because I understood that when battered women needed an advocate. And so when we tried to create a unified domestic court, which we desperately need, and again, the Gender Justice Unit, it was with the traditional model that we need to be able to prosecute people according to the way in which the courts operate. There was no thought of trying to do a restorative justice model in that context, for instance. So that was one way. Also, the organized retail theft unit that we got the $2 million grant for. Again, we were focused on prosecuting high-level crime, the fences, and going after the top. And that's, not necessarily traditional, but it is, in some sense, it's a way of making sure that you are advancing, so certainly prosecutorial goals that are not necessarily consistent with trying to reduce mass incarceration. So there's a lot of ways that a prosecutor can balance. It's not an either or thing. And that's something that I think people need to learn about how you approach prosecution and how you manage an office. It's not like we're just going to do all restorative justice cases, or we're not going to go after public officials, or we're not going to go after people who are engaged in crime. That's not there's no line there at all. It is a balance of making sure that making sure the system is fair, because that traditionally, and especially in Alameda County, that's our problem. Because we don't have a fair system of justice. We have a racially biased, discriminatory system of justice that we have to root out the preferences for people with power and wealth and position versus everyday people. And so those are the things that I think are really important for modern day prosecution and moving forward for Alameda County.
Thank you. Okay, and I would like to give you an opportunity, because I said I would give everybody equal amount of time. So why don't Ms. Price, if you would provide your closing statement, I'll time it and make sure everybody has that amount of time to provide their closing statement. So I'll set the timer, and I'm trying to do this as impartially as I can. I will ask you to provide your closing statement, anything else you would like to address, and then we'll move on and provide other people the same amount of time.
Okay, so first, thank you for allowing me to participate in this process. Many endorsements have been made in this race, and no one talked to me or gave me the chance to present my agenda or to respond to some of the misinformation. I have to talk about these enhancements because there's been so much misinformation about that. In the summer of 2024, we specifically modified the special directive to allow the deputies to charge a 5-year gun enhancement as an automatic gun enhancement if they wanted to do that. So the idea that they couldn't charge cases, and again, these are experienced deputies who were hired before me and have been there doing that job for years. And that's why we see so many of the inequities. But we were trying to address those. And I would just want to say the policy did not apply to misdemeanors. And when I left the office, there was a backlog reported to me of 1,000 misdemeanors. Somehow, in the 3 months after I left, it ballooned to 2,000 misdemeanors or 2,000 backlog cases of unknown genesis or type. And to say that a policy was ineffective on your first day that you got there, where you have had no conversation with anyone about the policy or had a chance really to measure its effectiveness, I think is fundamentally misleading. To say that the public dashboard was inaccurate, it was created by the same national data firm that created the same dashboard for San Francisco and Santa Clara. And so there was no basis after a year of preparing this to say that the dashboard was inaccurate, therefore we had to take it down. That's not true. If you had the dashboard, you would know the truth, that there are not thousands and thousands of backlog cases coming from my administration. So I am running because we need somebody who's going to stand up for fairness, who has integrity, and believes in transparency. Justice is in my DNA, and Alameda County deserves someone who is not beholden to special interests or billionaires, who's not complicit in discrimination and police misconduct, who's not hesitant to protect us from Trump's federal agents. I'm proud to have been the first non-appointed elected district attorney for this community. My endorsements come from people, famous people, and everyday people who are part of this community, who believe that this criminal justice system belongs to the people and not to the police or to the politicians or to the special interests. I have been standing up for survivors since I stood up against rape and sexual assault under Title IX at Yale. I have been fighting for racial justice since I was a 13-year-old child. I understand how important it is that this system treats everyone fairly. I am the only one in this race who is, in fact, a survivor of sexual assault, of domestic violence, of juvenile incarceration, sexual harassment, and vindictive prosecution by this office. So that is the lens that I bring. It is a broad lens tempered by a commitment to public safety and the experience of running an organization and setting goals as well as benchmarks and working with a broad coalition of diverse people, both professionally and in the community. That's the experience that I brought to that office and that I will continue to rely upon if you elect me as district attorney. So I ask for your endorsement. Sorry, Lori. Thank you.
Okay.
We lost you, Lori. You're mute.
I'm sorry, I muted myself. I will now go to Mr. Krishan, and you will have anywhere from you have 3.5 minutes if you'd like to provide a closing statement. So I will set it now. And
Thank you, Lori. That was a long closing statement, but that's okay. So in 2024, the people actually, they made a choice. And Ms. Price said she's the only one. What I'm going to focus on that she's the only one who was recalled among our other candidates. Now, I'm not going to give her that much limelight. I'm going to talk about myself, why me. Among all other candidates, I'm the only person who is actually representing people. I have built my practice, my career on the people. My clients, they are regular people. They are not billionaires. They are not badges. They are not cops. They are not big business houses, big corporations. I am helping regular people just like me. I have been to their houses. I have, talked to their kids, talked to their relatives. They are turning into my extended family. This is who I am. So the district attorney post we have is for the people. I am the people. This is the person who is going to represent you. You need that kind of person. You don't need that kind of person who is staying away from the people. My doors are open. I actually go out in the community. I have a regular life. I don't have a fancy life. So you need a person who understands the common problems of the people, who understand the basic requirements of the public necessity, that, okay, what it feels like when somebody is breaking into your car and you are watching that on your camera and you cannot do anything about that. What it feels like when you are opening a business and somebody is breaking the door and you're getting a call from your employee, hey, you know what, somebody is shooting. It happened with one of my clients right on the lakeside street next to the courthouse, but the shop is still there. But that feels bad. We are living in America. This is not the America I imagined. I came to United States for the better future, for the safer future, and it was safer before, but nowadays it is not going into right direction. That's the reason somebody has to come up from the ground, from the public, to represent the public, not to represent the big people, the big billionaire. The justice is for the people. Justice should not be concerned about the money. It should not be like if you have the money only you can get the justice. It should be for everybody. Teacher, nurses, CNA, Uber driver, students, the people living their regular life, they deserve the same kind of justice as well. It's not like only if only the rich people can afford the justice. Justice, public safety, and the justice is not about affordability. You should be able to have it all, and at the same time equal justice for all. Just because you have a bigger house doesn't mean that you need more safety. Just because you have a smaller house or you are homeless doesn't mean that you don't need a public safety. You need public safety for everybody, and I can provide that. I have planned for that. I have I have literally reason for that, so that I can stand up, I can walk tall in the community. Thank you.
Thank you. That was good timing. I said 3.5 minutes and 3 minutes and 20 seconds. So that was you.
I have a timer on.
You timed. Oh, okay. All right, great. Okay. And next up, Ms. Jones-Dixon, you can take up to 3.5 minutes as well. Go right ahead, please.
Thank you. I want to first start by saying I realize the importance of Ms. Price's journey to this space, being the first African-American DA in our county. As I've told her to her face, I appreciate her busting open that door. But I do want to say that the two things I think are most important in a DA is that they're not agendized and that they are not incompetent. Agendized looks like Pam Bondi, or the other side of that coin, going after our political enemies, politicizing cases so that you're recused from them, not allowing people who are prosecutors to do the job that they were called to do because of political opinions. We can't do that because it's not fair to victims. And then incompetence looks like basically the same thing. Finding yourself, again, recused from cases, not being able to move forward on cases, creating agendas that you never see the end of. And I think that in the meantime, victims get harmed because they're not at the center of what we're doing at the DA's office. That's not the case here. I think it's important for the DA's position to be an elected position, not a political one, because you too have to be fair and impartial, just like you must as a judge. And I say that because I think it's important to look at the support that I have across the county, not just in one space, but across the county, to include California Attorney General Rob Bonta, the former Attorney General Bill Lockyer, Senator Arreguín, Senator McNerney, Senator Tim Grayson, Senator Wahab, State Assembly Member Rebecca Bauer-Cahan, Liz Ortega, Buffy Wicks, former Assembly and Speaker Willie Brown, In addition to that, former State Assembly person Johan Clays and many district attorneys across the state. In addition to that, 4 of the 5 members of the Board of Supervisors and prior members of the Board of Supervisors, to include Keith Carson and Alice Lai Bitker. 4 of the 5 electeds in the county, to include Elise Castro, the superintendent of schools, Aisha Knowles, Board of Education trustee, also Fong Lai and Melissa Wilk. Every mayor in the county has endorsed me, and other community leaders, and that's not even getting into the labor support that I've received, to include the Labor Council, Building Trades, SEIU 10-1, Teamsters Joint 7, Alameda County Firefighters, Local 55, the Prosecutors Association, International Brotherhood of Electrical Workers, Local 595, and it goes on and on. The reason, of recent, I just got the BWAPA endorsement, which moved me for another reason. But the reason that's important is because the DA should be baseline. Anybody can be charged with a crime and anybody can be the victim of a crime, and it cannot be agendized the way that we do this job. And so it's very important to me that I keep that in mind, that I do this in a professional way and make sure that our office is thought of as a professional office again, and again, do the work on behalf of victims. Thank you so much for your time this evening.
Thank you all. And I want to thank everyone for being here this evening. We appreciate all of you participating, both attendees and panelists. This is what it's all about, is speaking to the people and learning about you and what you would bring to this role. So we want to thank you for that. And I want to remind members that you will receive a emailed ballot where you can vote for your preferred candidate and preferred measure. And I want to thank you for sticking it out this evening. And board members, I will email you and we will figure out a time to discuss. And I want to thank you for being here this evening. All right. Have a good night, everyone.